Sorry. Now you're good.
Okay, so now we're back live. So essentially what we did was, we've done transparency and public safety. So this is our public safety package.
Cameras aren't moving.
What we did was we took, do I need to stop talking or?
I don't know.
All right. Well, anyway, what we
There's
did.
no camera on you, so
It's
just-
fine. What we did is we took all of the bills that we had in our possession and we put them into buckets that dealt with public safety and transparency. Now, the transparency bill that we've already passed, that we just got onto the floor, I think it's on the floor tomorrow or Friday, which is the judicial transparency, that's already gone. But the rest of these deal with collecting data from the longitudinal, what is it called? The longitudinal data center. You've got parole and probation, and then you've got the Charles Sidnor's state's prosecutorial transparency bill up there as well. Then you've got things that are Baltimore-centric that are in our possession. So Senator Carter, to your point, we'll wait for a delegation letter. If you think it needs to go through delegation first, we'll do that. But we can refine the language now and work on it together today. And then we've got the absconding and the warrant apprehension piece. So this is transparency, public safety. So you've got 4 different buckets. One is already on the floor, and the other 3 we're going to work on today. So Josh will do bucket 1, the top 3 bills.
So this is a sort of.
And these have been they've all been consolidated into reprints that you should have either on your laptop or hard copy.
Yeah, so this package would be focused on kind of criminal justice data transparency, and the vehicle that's being used is Senate Bill 763, which requires the Administrative Office of the Courts to collect and make public information from the state's attorney's offices on prosecutions and prosecutorial decision-making. And we're having a couple bills that are put onto it. So if you look at the reprint, which is a reprint of the bill with amendment number 313225/1, the first piece which is being added to this bill is Senate Bill 587, which you can see is now at the beginning of the bill with the reprint. And that bill requires the Division of Parole and Probation to examine and review murders. It came in as murders. It's being changed to murders or manslaughters, except for involuntary manslaughters involving people who are under supervision by the department, and to examine those and for the purpose of recommending policies to the Secretary in order to reduce the incidence of those homicides. And the second piece of the bill, which is now at the bottom of the second page of the reprint, is that the department has to report annually on the activities it's undertaking in order to reduce those homicides, and also the numbers of offenders they supervise who are the victims of shootings, of murders or manslaughters, except involuntary manslaughters, or are charged with or identified as suspects in a murder or manslaughter, except involuntary manslaughter, a non-fatal shooting, a robbery, a rape, a police-involved shooting, or any other crime involving the use of a firearm. So moving on through the reprint, the next piece of the bill is what was originally in Senate Bill 763, and there are some amendments to that. Specifically, those amendments would remove some of the more specific pieces of information that would be required to be reported. Additionally, those amendments would include, or rather add to the list of dispositions that would need to be reported as part of the bill when a criminal charge is marked stead on the docket and when there's a probation before judgment. Oh, sorry, yeah, what was originally Senate Bill 763 begins on the 3rd page of the reprint, which is unnumbered in the criminal procedure article. Correct. And so you can see there's some change to the definitions there. On page 2 of 12, this is where new dispositions are being added to the list of dispositions that need to be reported. So marking of a criminal charge as stead on the docket and a probation before judgment. Moving on to page 3, again, there are some definitional changes that reflect the other changes in the bill. And starting on page 4, you can see some of the specific pieces of information which were struck from the list of information that has to be reported. And that continues through page 5 and page 6, all the way through into page 7, where there's an additional change which clarifies that any information disclosed under the bill may not include the name of a defendant. That's in addition to a prohibition on including any identifiable information relating to a witness. And then again, starting at the bottom of page 7 of 12 and continuing on through page 10 are additional reporting that is struck from the requirements of the bill. And then, again, on pages 10 and 11 are additional items which requirements are being struck from the bill. And then starting on page 12, the bill incorporates, or the amended bill rather, incorporates certain elements of Senate Bill 277. So that bill, as it came in, basically required the Department of Public Safety and Correctional Services to share certain criminal justice-related information with the Maryland Longitudinal Data System Center, which is part of the Department of Education and conducts sort of general research. So the department had some concerns about that requirement, and they got together with the center and agreed to enter into a memorandum of understanding to share information. And they both agreed that there just needed to be a simple definitional change in order to facilitate that. So the piece of the bill that made it into this amended bill starts on page 12 of the reprint, specifically at the very bottom of that page and continuing on to the last unnumbered page. It simply alters the definition of student data to remove a prohibition on sharing criminal and SINA records. So that got everyone to a place where the department and the center believed that they could enter into an MOU to get the information that the bill was seeking.
So we can go, look, this is all subject to change. This is just, this is just a starting point. So we can go, thank you, Josh, for the overview. We can go start from the beginning and just work our way through. If people have specific questions, we can jump around, but. What? Sure.
Looking at it, but, and this isn't, this is
all in one
stuff
bill now?
reported by the state's attorney. I'm sorry, this is stuff reported by the state's attorney, but I just noticed, where the defendant was determined eligible for court-appointed counsel and where their determination was made. Why would that be something reported by the state's attorney, and how would they necessarily know?
Can you go to the page you're on?
Oh, I'm sorry. 4 of 12 in 763, the reprint. Okay, well, I said this is skipping around. It's probably a lot more. I just
I
noticed
don't
that.
want to go page by page. I can just tell
We can
there's
go page
two
by page.
bills
I
that have
just-
problems. I can answer questions.
I want to read every word on every page, but I have questions on certain pages. And if we do the second page before we do the fourth page, right? So for example, on page 2 at the bottom, it says on or before, the division. Which division? Is that Division of Parole and Probation? What division is that that's reporting?
On the bottom of page 2 of 12, or
The second page is
the
reprint.
second page? Yeah. So that's the Division of Parole and Probation, because they're in the parts that are in the Correctional Services article
Gotcha.
there.
And then it says actions, the last line says actions taken by the division under section 6104A, blah, blah, blah. What is that section?
So that's the new item 8, which is on the same page above that, when they examine and
Oh,
review
up there.
murders or manslaughters, except involuntary manslaughters involving people under their supervision.
Okay. Thank you.
So, excuse me, going through the list, looks like Senate Bill 277, then you've dealt with the issues and the department, everyone's on the same page. Senate Bill 587, the department had a bunch of, outside of the preamble, which, is that gone now?
The preamble is gone.
Good.
yeah.
And then, but they also had problems with the bill. Is that worked out?
No, the only change that was made was to use that phrase, murders or manslaughters except involuntary.
All right, well, that's an issue, because the department had a whole bunch of stuff in there.
So I'm actually confused by what you said. You said 277 is worked out. Where? Where's
The-
277?
They did a memorandum of understanding. I think they wiped out the whole bill and they just did a memorandum of
So
understanding.
there,
to
it's
save
not in the
data.
bill. There's no bill.
So there is a definitional change at the very end on page 12. It starts, it's the portion of the bill that's in the education article. They just agreed between them that they needed this definitional change so that they could enter into the memo of understanding.
587 still has issues, at least from the departments. If you go to their testimony. So once you get past the long fight over the whereas clauses, I mean, there's one, let's see. I mean, there's a bunch of bullet points here they're bringing up. SP would require DPP and the secretary to examine new murders involving supervisories or either suspected. This is already being done. I mean, there's like 10 bullet points here of issues they're bringing up with the bill.
Is all of 587, like, what part is in and what part is out? I'm not able to really tell.
So everything besides the whereas clauses is in this new amended bill, except for the slight change in phrasing involving murders, manslaughters, except involuntary.
Requirements in SB 587 for which DPP currently has mechanisms in place for tracking homicide, non-fatal shootings. The mechanism currently in place to track homicides, non-fatal shootings are not automated. I mean, this is just going on and on and on with, I mean, it seems like this needs some work with the department before we roll that part of it, you know, so we're not creating things that are already being done or won't work.
So provisions begin at the second page, which is unnumbered, and they go down through the end of the piece. So on the next unnumbered page, it ends where the criminal procedure article begins.
Okay, page 5?
It's the second page of the bill, which is unnumbered in the reprint, and the third page of the bill, which is also unnumbered. Sorry, second page of the reprint.
Okay, so it starts with the examine review.
And then the second is, I'm just looking, 763 had a ton of state's attorneys in opposition. Has that been addressed, or is that?
I know that some of the pieces of the bill were taken out. I wasn't involved in those conversations, so. They have seen them, I know that. No.
I mean, that to me would be a problem if we're trying to put out a package dealing with crime, and we got a proponent of the, or not proponent, a portion of this that the state's attorneys and a bunch of other people who are in law enforcement were in opposition to. I have concerns about that.
And most of it was because of cost, not necessarily because of what the bill was attempting to do. And as you can see, a good portion of the data points that I was asking for, they've been struck. So I don't think the cost is going to be quite the same, nor the burden on those state's attorneys' offices.
I don't believe so, no.
On this with corrections and MSAA. So Sidnor, Carter, Huff, are you willing?
Sure.
All right, so three of them, you sit down and we'll work with Departments of Corrections and MSAA. I know MSAA has seen it, but I don't.
But just so we're clear, so 763 would now be the vehicle that would encompass the contents of 277 and 587, so they'd no longer be.
bills.
all the blocks are there. The buckets
Every bill in
Oh,
this
they'll-
voting list is in here.
Yeah,
Every bill is in here.
no. Just those three.
Yeah,
Just those are the buckets.
That's exactly what I was
Yeah,
saying.
just
Oh,
those
really?
three.
I thought they were all in here. I was
No, they're not.
confused.
Just three different buckets.
I got it,
Okay.
763, so what's the other,
All right, so that's the do out there, okay, Josh? So we got, all right.
Oh, but so, back to my question.
Yeah,
then.
absolutely.
You've got, actually, it's interesting, because that was all the bills I just flagged, of this whole voting list, everything I just flagged that had opposition or problems in testimony was 277, 587, and 763. They're all in that block. You got the problem block you created there, Sidnor.
So the three of you guys are gonna work it out. There you go.
You took McCrae's problem bills and brought them in yours.
All right. So let's go on to bucket 2.
So the second block of bills is actually those 3 bills, Senate Bill 586, 602, and 667, that you see in the second row in the dashboard, or not the dashboard, the whiteboard, are all combined under Senate Bill 586. So what I'm going to do is just go through each of those bills and tell you what they do as drafted. And then we'll walk through the reprint that's in front of you, and that should be reprint for Senate Bill 586. That is amendment number 333722/1. So Senate Bill 586, as it was introduced, requires the court and the Office of the State's Attorney to notify the law enforcement agency that arrested a defendant within 48 hours if a defendant charged with certain crimes is released before trial, and those crimes were first-degree murder, second-degree murder, attempted first-degree murder, attempted second-degree murder, robbery with a dangerous weapon, and armed carjacking. During the hearing, the bill sponsor introduced an amendment that would have made this Baltimore City specific. So what would have been required under the amendment and what's required in your reprint for this aspect of the bill is that the Department of Public Safety and Correctional Services notify the Baltimore City Police Department within 48 hours if a defendant is released. And you may recall from the bill hearing that it eliminated the specific crimes that that notification would need to happen for, and it expanded it to just any release. The second bill that is in the packet is Senate Bill 602. Senate Bill 602 establishes a jobs court pilot program in the district court sitting in Baltimore City. The purpose of the pilot program is to reduce recidivism by offering defendants an opportunity to participate in full-time job training and job placement programs as a condition of probation, or an alternative to incarceration, or a condition of pretrial release. As the bill's drafted for fiscal '24, the governor is required to include in the annual state budget an appropriation of at least $500,000 to the Baltimore Workforce Development Board to be distributed to local workforce investment boards or other nonprofit entities that participate in the pilot program by identifying employers and training programs. And the last bill that is in the packet is Senate Bill 667. Senate Bill 667, as drafted, requires by March 1st, 2023, and each year thereafter, for BPD to report to the Baltimore City delegation of the General Assembly regarding firearms that are destroyed, seized, or recovered by BPD during the preceding calendar year. As drafted, if BPD does not submit the required report, the Governor's Office of Crime Prevention, Youth, and Victim Services is prohibited from making any grant funds available to BPD. So a few things to note about that. And I'll start with this one. There are some changes from the language as how that bill was introduced and the reprint that you have in front of you. So with the reprint, it instead of going to the Baltimore City delegation, that report would go to the governor and the General Assembly. It's also important to note that it terminates after 5 years, which coincidentally matches up with the termination of the Baltimore Jobs Corps pilot program under Senate Bill 602. I do want to flag for you, and there were a couple of amendments that came in recently, and they were from Senator McRae's office. For the Jobs Corps pilot program, Senator McRae's office had submitted an amendment that would require an interim report to the Governor and General Assembly from the judiciary on how the Jobs Corps pilot program was progressing. Currently, the bill provides for a report on June 30th of 2027. The Administrative Office of the Courts would be required to report to the Governor and General Assembly on the operation and results of the pilot program. So this just sets that interim report. And Senator McRae's office had also asked for an amendment with respect to. Sure. The GOCAP funds that would be prohibited from being distributed to BPD with the firearms reporting, instead of any grant funds, it would be set at 50% of the grant funds that they would be eligible for. And then finally, there was a amendment to bump out the funding to Baltimore Workforce Development Board. As the bill was drafted, it was only for 1 year that they would receive that $500,000. That's fiscal 2024. This would make that funding through 2028 and also makes a correction, so it bumps out the effective date for that by a year.
We didn't get approval for the amendments, we just got approval for the bill as drafted. So
Right.
let's just talk about keeping aside Senator McRae's amendments, let's just go from the front, beginning with field questions. Go ahead, Senator Hedelman.
Reiterate concerns I had, which I expressed at the hearing, is that we're allowing the police department to sweep in everybody who is being released rather than the people who have been detained as a result of the most violent crimes. I just have concerns about that. 586.
No, we haven't gotten that one yet. Okay.
I agree with Senator Hellman, as I expressed at the hearing, and I also said that this is, even though it's arguable because it came in different, but it's arguably a Baltimore City bill that should be vetted by the Baltimore City delegation, in my opinion, because it's only dealing with Baltimore.
Yeah, let me
City
just say
Police
this.
Department.
I'd like, what would be ideal is if we were to engage stakeholders, refine the language here, and then, get the bless off from the city delegation. If it's determined, then we can roll with it. But, we need to have that preliminary discussion here before we do that. Senator Katzlik.
Just respond to that one, because I understand people concerned about giving police too much information, but in every other jurisdiction, mine, Senator Hedelman's jurisdictions, because your sheriff's, you have your sheriff's office does the court stuff, okay, but your jail is still owned by the county, as are your police.
County, only in Baltimore do you have a state entity running the
Right.
jail.
Well,
That's something, the issue is, it was represented to us that every jurisdiction does this, and I checked with my county, and my county doesn't do this.
doesn't do,
Notification on
so,
release.
because they know already. Your sheriff's, your sheriff, or Chief Hyatt's detention center releases the prisoner, so Chief Hyatt knows. She can willfully not want to know, but she owns the detention center, she owns the police. Her detention center just released them, her police know.
Better yet, actually, even further on that. Because Baltimore County, your county executive basically has a police force, they have control over it, whereas in the Baltimore City has no control over that jail because the state of Maryland runs it. And so the coordination between the two can be non-existent. Whereas in every other county, they know, especially if you have a county executive as a police force.
This is inoffensive to me. I don't care.
Baltimore Police Department is still a state agency as well.
Well, technically,
I guess
but you know they're under the mayor.
The issue for me, too, aside from what Senator Hellman suggested and what I voiced at the hearing. If it's to deal with violent crime, that's what it should be. And then I believe and know, I don't just believe, I know for a fact that the information is already available and accessible, so I don't know why we need to create this extra step. Well, officers are making these arrests. It's their responsibility to follow the fate of the person that they've arrested. I use case search every day. I can find, the fate or the outcome of a person that's been arrested and what happened at their initial appearance hearing or their bail hearing. So I had concern that it's like an unnecessary step, and it also is too broad. That's just what I thought. I know, I completely understand the view that this is the closing of a loophole because it's done everywhere else, and it's just the Baltimore City has a state jail versus whatever, but I don't think that it's necessary, and if we are gonna pass it, well, as I've stated before, I think it should go before the delegation, and I think we should consider limiting the data and not sweeping everyone under it.
Like, every other jurisdiction has access to this information. I think it's very, it's cumbersome to go,
They have access too.
I know, but it's just
It's
that's
public
not, that's
information.
not something that, your law enforcement agencies don't need to be spending time, trolling case search.
But so I guess it's also, there's something just really bothers me.
I know,
Which
I
is
hear you.
that they're claiming it's notice, but then they're adding all these other things, like claiming there's gonna be some type of coordination of services. And I think if you, let's be honest, have the bill have integrity. If it's notice, and just say it what it is. But don't act like this is all about coordinating services, which is not the truth. So I'm just saying, let's just have the bill say what it's gonna say. I don't know if the change does that or not, because I haven't been able to sift through it all, but if it's gonna be a notice, let it be a notice. Don't claim it's some type of effort to coordinate and help people, because that's not what it's designed to do.
Fair enough. All I know is that if every other jurisdiction has access to information to coordinate, the commissioner came in and asked for it, the mayor came in and asked for it, to help them, sorry, go ahead, Senator Bailey.
So I guess the difference is, Senator, when you do case search, you look up a certain individual to see what the status of that individual is, correct?
Yes, sir.
Okay. So that's where the disconnect is, right? You have access to case search.
So like everybody does, yeah.
That's right. And what you're looking up is that one individual. You're seeing if this one individual, what his or her status is. What this bill would do, the difference, the way I understand it is, you don't have access in case search to say who was released today.
It's there. It shows when somebody's released.
It doesn't
held
show
on
the
bail,
entire
held
list of
without
who
bail.
was, case search doesn't show the entire list of who was released. You have to look it up by individual.
Well, actually,
And that's the difference.
there are ways to finagle case search so you can get a data dump. And the reason I know this is before we ended so many money bails, all the bail bondsmen in the whole state of Maryland would input the data so that they would know everybody that was released and held, so they could reach out to them to try to get the bail. So there are ways to manipulate that, but just saying.
Right, so that's what I'm saying. The normal way you're using case search and you're applying it, you say, I don't agree that that's the same way that the commissioner asked that he wants the information disseminated to his officers. Right, they're not gonna sit there every day and look up every defendant to say, is that person, what's the status of that person? They're still incarcerated. Right, they wanna know if that list is generated, who's being released.
I don't want to debate the thing forever. And again, I'm still trying to look through to see what the exact language is and the changes. But I also recall some discussion at the hearing about the reasons for release, which you're never going to see that. The only way you're going to get the reasons for release is to watch the bail hearing and see what the judge articulated as to the reason for release. You're not going to get them a data dump. So that just didn't seem like it made sense to me. But I don't know if it's still in the bill. It's just something that they testified to.
The more fundamental issue is that, especially with regard to the people as the bill came in with, who are, accused of the more violent crimes, is why are they being let out at all? I mean, honestly, if they're, in terms of murder and the first.
Presumption of innocence.
No, I know, but
You know, a lot of first-degree murder aren't
But
walking out of
nobody,
that jail.
so that's not true. Like, you are not gonna see people charged with first-degree murder that are being released. That is not happening.
that's my point. I mean, that's my point, which is why I question.
If there is extremely flimsy evidence and no probable cause, a judge might release on conditions on a serious crime like that, but they're not gonna do it on murder. They're just not.
So where does it say the reason?
And if anyone can say that show that I'm wrong, show me where someone's been accused of murder.
I think I asked that question at the hearing, because.
It doesn't
these-
happen.
The list of these crimes, you're kind of be astounded if they were released.
Where
But
does it say
anyway,
Where does it say the reason for release? I'm not seeing it in the,
Hearing that that's what they wanted to know.
this just says the release.
I got you, but that's what they said.
Wait, just to clarify, if you're looking at the reprint on page 2, what it provides is, it says, if a defendant is released before trial, the Department of Public Safety and Correctional Services shall provide notice within 48 hours of release to Baltimore Police Department. One thing to note, just about the form of it, because it did come up at the hearing, Baltimore Police Department said that, you know, their ability to sort of sift through all of the information would depend on how it was presented to them. So just below that, below line 5, it provides, notice provided under this section shall be provided in a manner that allows for sorting and filtering of the information provided by the Department of Public Safety and Correctional Services. So, that's page 2 of 2 of the reprint, just below line 5.
Sort that column, and all the bad shit comes to the top.
available to the public
Could get it through.
or
if you
not?
Search on MDOT.
I don't think it's prohibited from being released by the department. I think you can find out if
I
somebody's
guess
been released.
one question is this something that we want as part of our transparency effort, made available via their website or something?
So you can go on the case search, and you can search, and they would say bail hearing held, right, and released on bail.
But then
You
you,
have to
then
go
you're,
through each guy.
you're kind of arguing against yourself, because you didn't want people to be even notified that everyone's getting released. Now you're gonna put it on a website.
No, I'm just, my point is that only, I like the bill as it came in with just those categories.
Got it.
And then transparency.
So they testified that there was some agreement, why they changed to broaden the categories, and that quelled or got rid of the opposition or something. I don't know what those, I wasn't privy to those discussions, but I am curious, we don't really know, what was the problem with leaving the bill as it came in? Which I agree was more palatable.
So I wasn't worried about deleting the categories, because I had some concerns about the categories, that they were under-inclusive. And we could spend all evening debating on what ought to be in the categories and what shouldn't. I don't want to do that. My question was 48 hours? Why can't this information be provided more quickly than 48 hours? That gives them 48 hours. I proposed 24 hours.
Case is heard, it's usually available like the very next day on case search. Sometimes even faster. I've actually seen later in the day when something happened in the morning. Not all the time, but it's always available the very next day, so I would think 24 hours would be reasonable. Especially if ostensibly we're concerned about victims and victim notification.
No, the people they released that day would already be in a list from, who do we release today? And you email that to the police, and you're done.
Agree. Which I would also argue we don't need a bill for.
All right, let's do this.
I agree.
So we're not going to vote this out of committee obviously today, but I would like to adopt this amendment to create this vehicle. And then we can talk about the 24 provision, and then we can talk about if we're going to be under-inclusive, over-inclusive, or where you're going to enumerate. So can we adopt this amendment so we can work on it? All right, great. Is everyone okay with 24 hours instead of 48? Great. Yes, sir.
That'd be an issue to say contemporaneously.
Contemporaneous notification? I don't know how that works, but contemporaneous notification, like immediate, I don't, yeah, I don't know how that works.
I mean, there's nothing that prevents them from doing that, it's just.
They could do it, it's within 24 hours. though.
Especially when these hearings are now still often virtual. Just saying.
All right, let's move on to whether we're going to enumerate what you're going to collect. You're going to collect everything. Are they going to notify of every release?
It says prosecutor right now. Oh, I'm getting ahead of you. I'm the next paragraph down. Okay.
Let's not hop to that issue next. 'Cause
I
that,
jumped down a
yeah, yeah.
paragraph. We'll go back.
We're on whether you want to notify for every release or do you want to enumerate. We could take a vote on it.
I would propose putting that in how it came in, enumerate.
Second.
So we can roll it or we can do a.
I'd like to respond.
Yeah, actually, absolutely. Go ahead.
What I would envision happening is, at the end of every day, the detention center would probably have, I imagine they have this stuff in a data form, a spreadsheet, and it's got Frank Jones released today, on bail, charged first-degree murder, right across there. And then they list it all up, end of the day, they take that spreadsheet and they email it to BCPD. They get it, and they take that spreadsheet, they download it, and they sort it. And the guy who was released on his own recognizance on the charge of trespassing, that goes to they sort it. Trespassing's at the bottom, minor drug offenses at the bottom. At the top, they sort it out, so it's got murder, rape, that kind of stuff. They take those, and then they can use that to, notify whatever their internal system is. They start shooting out email to the officers involved and saying, here's, your suspect just got released. If that matters to you, go protect your victims or your witnesses or whatever. And the stuff, the trespasses, I mean, they got it. If they don't, it just seems so easy to do. And if they, I don't see any reason for not giving that to BCPD. There's nothing like it's secret that Fred Jones he's out. I mean, why is that a secret? He's out. I mean,
It's not a secret. It's information they already have access to that we don't need
by
a bill
going through
for.
case search,
But
that's
since
not
we're taking the
accessible. It's not reasonably
Since we're
accessible.
taking the trouble to do a bill, and we are ostensibly attempting to address public safety in the nature of violent crime and crimes that involve victims, I would suggest that the bill do what we say that it's designed to do. That's all I'm saying. And I understand you're saying, oh, it's harmless, they'll pick through it and they'll say this is important, this is not important. I understand completely what you're saying. I'm just saying that's not what the,
I wouldn't oppose if we said that the data had to include, we don't limit it, so the data must include all. If they give them more, they give them more. If you want to say, to keep the bill consistent, then to show the priority, legislative priority must include all crimes of violence, I think that would be a good solution.
Well, I talked about how I thought it was under-inclusive, so what it doesn't include are sex crimes. So if a guy assaults his girlfriend, tries to sexually rape her, and he gets arrested, and now he's been released on bail, it seems to me that's just the kind of information the police would want to know, so they could go out to her house and make sure that she's protected, so he couldn't just go right back and do it again.
And we could come up with examples like that all night.
Exactly.
I was just gonna say the same thing, yeah. I mean, all the firearm offenses aren't in here. I mean, people who are caught illegal possession of guns, assaults aren't in here. I mean, you get these cases where people go out and they assault people again and again and again, so I'm not for limiting this. I just leave it unlimited. It's just information. The police, if they wanna know it, and you'll know when you go to your delegation if they wanna know it or not.
But it's a release, and the guy violated the peace order, so they arrest him for violating a peace order, and then they release him. The neighbor needs, if it's a bad one, the neighbor will want to know. So we're going to have to do, it has to be a pretty extensive list. We want to go through all that, but it's not just crimes of violence, like they say.
It's been motion seconded. We can roll it and see what you want to do. You want to do roll call, or you want to just, is everyone okay just kind of keeping it as it is with everything? Or you want to press it? You pressing the vote? When you press it, press it. Okay. So we're gonna roll call. So the amendment is to restore the list to murder in the first degree, murder in the second degree, attempted murder in the first degree, attempted murder in the second degree, armed carjacking. All right, roll it. And the motion's for favorable. I'm voting no.
Whose
Senator
amendment
Lee.
is this?
It's, Jill's.
You know, I haven't had a chance to get it, so can you pass and then come back to me, okay?
Senator Casserly.
No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Watson.
If I vote no, that means they get everything, right?
Yeah.
I vote no.
Senator Bailey.
No.
Yes. Senator Carter.
Yes.
Senator Huff.
No.
Senator Lee.
And this is the current,
So this will put it back, so right now,
yeah.
the amendment is to put the list that I say, the
Yeah.
bill, that's all that the public correctional facility would tell the police about their stuff. The alternative is that they would tell them about every release. So to include those gun crimes, those sex crimes we were talking about, those peace orders that we were talking about, all those things. that we were talking about.
You could always add
I'm
stuff
just saying.
in. Doesn't have to be all or nothing.
I mean, whatever,
Yeah, everything,
everything.
which is what your county does already. You're in my county.
Okay, yes.
Chairman Smith.
So I'm no on the favorable.
I don't know, how's that work on amendment?
No, yeah, it fails.
All right.
It was,
6 no's.
yeah.
6 no's, yeah, yeah. All right. Let's go to the Vine issue. So now your issue, which was the Vine.
This is a change from the bill as it was introduced. This was in response to an issue that was raised by one of the committee members about the notification of victims through Vine. So currently, there's a procedure for victims to register to receive notification about changes in the case, including the change in pretrial release of a defendant. What this does is there wasn't a really good way to make Vine sort of automatic. But what this would do is it would say that if a victim or a victim's representative hasn't filed a notification request to be notified of those changes in the case, then the prosecuting attorney would make reasonable efforts to inform the victim or the victim's representative of any change to the defendant's pretrial release status. And I think in speaking with the chairman, it sounds like that's coming out, or...
Yeah, just can you talk about the notification, the conversation we had with MSA? Can we disclose those? What are we talking about?
I'm not...
The question is, so I like the idea. It's like an almost impossible thing to actually do, apparently. But I like the idea. So apparently so when talking to some of the state's attorneys, you have to opt in to Vine, obviously, and it's hard to do that. And I don't think that you can, now this is a casual conversation I had, but like one of the state's attorneys we're talking to said they have trouble doing that if they're not a part of the case, and if they're not, it was just a very logistically impossible thing to do.
They
The
would be in
victim
the
is, but-
file.
yeah.
But this, oh, you mean victim's rep would be?
Yeah. I don't know enough about how Vine works, but I just know that it was impracticable is what people were saying. It was not.
I'm sorry to interrupt. Where are we exactly?
Sure. So this is in discussions earlier in the week. People wanted to, Vine, this victim's notification system, so they wanted to make it automatic. So instead, right now you have to like sign up and register.
It's on the reprint we're looking at, which is reprint number.
So it's on page 2 of 2.
722/1, that reprint on page 2, halfway down.
Okay.
Yeah.
So my question is if a, because it seems like we're all over the place, so when a sex offender gets released, right, from prison, somehow they automatically show up where they're currently located in the National Sex Offender public website, correct? You know their location, don't you?
Through registration, as far as pretrial, honestly, I'm not sure. Yeah,
If it's-
like, there's no,
No, even if they're released on pretrial, if they had this prior offense,
oh,
and they're released, and I'm getting back to getting that information back to Baltimore police, that they know this person is back on the street. I guess I'm trying to get to, how is everything updated? We're talking about these data dumps and everything. My concern that I had, which is why I wanted to expand it from just those categories, if a sex offender is released, how do I know that the person hasn't moved back into my neighborhood?
Yeah, to be clear, we defeated the amendment that would limit, so right now, it's
Everything goes.
everything.
Okay.
Yeah,
But I still have the question.
yeah.
yeah, I would need to talk to Department of Public Safety specifically about how that information gets updated. But I guess your question is,
Well, you're talking about Vine in one instance, sign up and get these notifications. You have other people who have a legitimate fear of reprisal or somebody coming back at them who, was away for a while for sex crime, is off on pretrial release. Who knows where they are, what they're going to do. And I'm just trying to figure out where we've talked about data all session. How does all this get updated so that I know that somebody's back in my neighborhood?
so you're talking about how would Vine be updated? How
Yep.
would the
Sex registry.
sex registry? That I definitely need to talk to Department of Public Safety about. I think they probably have a good answer as far as, when and how often they do operate a public website that's searchable. But as far as whether that's an immediate update or what the process that they go through on that is, I need to talk to
So in
them
Baltimore
about
City,
it.
jail's released this guy.
Right,
The information is going to automatically go to Baltimore police, right?
under the bill,
Under the
yes.
bill. They'll know. And they're
Right.
going to do whatever protocols that the chief talked about to make sure the public is safe and those types of things.
Right,
But
and
if-
when we say automatically, I do want to clarify, it's within 24 hours, so I'll couch it that way,
That's pretty fast.
right?
And so they're going to put their protocols in place and do what they think is necessary to protect the public. And I'm going to assume in some form or fashion, the person who the potential crime was, happened against would be notified some way, some fashion. But if the normal course of circumstances is for me to be able to go to the sex registry and see if this individual is out and about, who's responsible for that reporting? Is it the Baltimore police once they get the data from the jails? Is it the jails once they release the person?
As far as the sex offender registry, who maintains that? That's the Department of Public Safety.
So how does the Department of Public Safety know that Baltimore City Jail released this offender?
Yeah,
Because the sex registry, of course, when you're released, you go to the sex registry when they're released, and they would have to give, on release, they have to state an address. So then it goes into the database. But then it's the individual's responsibility to update that, and it's a crime for them. They can be put back in jail if they move and don't report into the registry a new address.
That's a self-reporting.
But there's no police out there unless they're on parole or probation still. But for a lot of these people, they're not on active parole and probation. And it does come sometimes where they don't in fact notify that they moved to another city or something like that. And if that happens, then that's a crime, and they could be prosecuted for not updating the registry.
Okay, all right.
I just add to that, if someone is a registered sex offender and they get arrested, it's prohibited for a commissioner to release them. They have to be held and see a judge, and so then under this bill, that would be reported in every other kind of report. But They can't be released at initial appearance hearing under any circumstance.
So Senator Watson, I just wanted to clarify. So your question was about the sex offender who is released and they're out and about, and basically this is their change of address essentially from their residence in the correctional facility to wherever they're going to be like living on release? Or are we talking about somebody who's a registrant that goes out and reoffends and is now being released on the new offense?
You made it quite confusing. I can't answer
Okay.
that question.
But Senator Cassidy's correct. It's on the defendant to go and update their address with law enforcement as far as where they're living at, and that's how the registry itself gets updated.
But what we're talking about here is all pre-trial.
Right.
So it's all, so that scenario, unless somebody reoffends, is not.
So, because we're talking about the conditions of release, right? So they're talking about prior to trial. I know that in the federal system, they were completely clear, right? Crystal clear about what those conditions of pretrial release were. What because they were assigned, the minute they were done that, they got a probation officer, right? That was assigned to them immediately. Those conditions were laid out. I think that there's something that we're missing here. I think that there's something that exists that none of us have been in that situation, that we're like, well, wonder what this is and wonder what that is, that we should really know what the conditions of pretrial release are.
It's fairly flexible what the courts can order for that, but there's a section of code that's coming to mind that I could probably pull up for you if you give me a minute.
Okay.
I know we were talking about the Vine system earlier, and I was just telling Senator Watson that, you can look at the system. They have a website, vinelink.vineapps.com. Just for any of those who may not know, you can kind of see what victims may see in order to have to sign up, so.
All right, I'm going to get some information from a state's attorney that I had a conversation with, so I can better articulate why it was probably not possible, but I like the idea, but, so we'll put a pin on that.
So, we remove this? Can I move, we remove this section on the middle of page 2 that you were talking about, or is it already done?
It's not done yet. You can move it, I mean,
So I moved it on page 2 of the reprint, that Roman numeral 2, if the victim or the victim's representative, that based upon the impracticality of it, that we delete that paragraph right there.
The reason why before we make that, before we did that.
keep marching down. Everyone's okay with the jobs court pilot program? Okay, so once we get that information about the Vine, my recommendation was we would not vote on this, but would have this clean version so that it can be heard and presented to the Baltimore City delegation on Friday, if they allow it, so that you all can give us a recommendation and bless off.
For just the,
For this entire package, for 586, 602, 667.
I got you, except that it all does it all just pertain to Baltimore?
That's all Baltimore, yep.
Did we vote on the other?
Jobs court's just the city.
Did we opine on the other ones yet?
You did, but so the jobs court, there's nothing that's changed.
Yeah, I remember
And I think for 67, there may not be anything changed. So 586, you'll need to just give us a recommendation. All right, so we'll leave that one Vine issue pending. I'll find out. If it's not possible and it's to your satisfaction, we'll remove it. If not, we'll keep it in. All right, Josh, let's go on to 287 and 585.
So the next package is reflected in the reprint you have, which is a reprint of Senate Bill 585 as amended by 673323/1, and it combines the two aforementioned bill. Going through the reprint, starting on the bottom of the very first page, is where the provisions that were a part of Senate Bill 287 appear. Senate Bill 287 altered the definition of absconding as it relates to technical violations of probation and parole to clarify that absconding includes leaving an inpatient residential treatment facility that an individual was placed in under a court order for a drug or alcohol treatment without the permission of the administrator. So this change would have the effect of making that a non-technical violation, which means it would not be subject to the incarceration caps that are part of the Justice Reinvestment Act. So that piece of the bill goes from the bottom of the first page there to the very top of the second unnumbered page. And then starting with the public safety article is where the provisions of Senate Bill 585 start. So Senate Bill 585 creates the Warrant Apprehension Grant. It requires that for fiscal years 2024 through 2026, the governor include an annual appropriation of $2 million for the grant fund, which is administered by the Governor's Office of Crime Prevention, Youth, and Victim Services, and gives grants to local law enforcement agencies for the purposes of reducing warrants in the agency's jurisdiction, for increasing coordination and cooperation between local law enforcement and state and federal agencies regarding outstanding warrants, and reducing the number of outstanding warrants related to violent crimes.
And I think I may have asked a similar question at the hearing, but just in dealing with the term absconding, just wanted to get some clarity. There is a intent here when we're talking about absconding. So I mean, somebody who's just leaving an inpatient residential treatment facility, that I'm assuming there has to, your intention is that there's some intent not to return, not necessarily that they're going to go visit a family member and without permission or anything like that, right? Okay.
So the bill requires that it be without the permission of the administrator of the program.
Okay.
Bill that we passed it last year, the same language.
This doesn't cover you.
So we can work off the bill as is? All right. Sounds good. All right. Further discussion on the bill. So we can. All right. Understood. Okay, so the bills before you as amended, motions for a favorable. It's been seconded with amendment. All right, we'll just roll. Is there?
The one that you just adopted.
The one we just adopted, just to make this, to collapse the two bills together. Yeah. Is everyone okay? Okay. All right, it's unanimous. All right, so of the.
I want to be a co-sponsor since it happened with mine.
Oh, yeah. Yeah, we'll add center office as a co-sponsor. That's fair.
I want to be a co-sponsor on 763 without the 586 part.
Well, 763 is a different package than the 586, so
Okay.
you can do that.
Okay, that's so,
But we didn't
The
vote on
line.
it, so she can't be a
I know.
co-sponsor yet.
Yeah, we haven't voted on it yet. So here's what we'll do. All All right, so that bill's been voted favorable with amendments, and we will hold this so that we can have the rest of the package, so the report out, we can hold it until the rest of the package reports out. Senate Bill 586 package, we're gonna tack back to that real quick so we can handle the Vine issue. I think we got a response, so if we could get to Jamie with the response.
So it seemed like there could, one, be some logistical issues. You know, obviously, like, you could make it so that they need to get all of the requisite information that you would need to feed into Vine. But also, it seems like there's maybe some policy issues that the prosecutor that I was talking to had brought up, which was that there are a bunch of, really a lot of different permutations where, you know, you have individual victims, you have corporate victims, you know, and you would basically be doing all of that for them in that notification. There may also be, even in the context of individual victims, apparently individual victims who wouldn't want to necessarily be notified, you know, that they just may not want to have any relationship with the case for whatever reason. One example that was provided was also that, you know, depending on what number or what email address, you know, was obtained and fed, you know, automatically into Vine, you know, you could have situations where that is a shared number or a shared email address, particularly in the case of domestic violence. You've got multiple family members involved, and, you know, suddenly it starts looking like the, you know, there's something that maybe somebody who feels a certain way about the case is now thinking that the victim is involved with, you know, the process in a way that they don't approve of, or, you know, it could be that the victim doesn't want members of their family to know about, you know, the particular case for whatever reason. It just, you know, it seems like they're, and this is just the information I'm sort of paraphrasing and reiterating, is that there's just a lot of different permutations as far as victims and different crimes, and you know, the information that they may want to receive and may want others to know that they're receiving. So that was sort of the response that was given.
I would have, I'm curious with the state's attorney that you spoke with, if they have some sort of a victim's advocate, is the victim's advocate under any duty right now to make certain that the victims know that this Vine system's available for them?
So that information actually is required to be provided to victims. This is how you sign up for Vine. You know, these are your rights as a victim. That information is required to be provided to them, yes.
Thank you.
Sort of on Vine, because so victim gets violently assaulted today, they arrest a defendant. When does the victim then get the opportunity to go on Vine? Is it as soon as they've reported the crime, or is it after conviction, or not after conviction? I mean, is it after an indictment been issued, or?
You know, off the top of my head, it is laid out in statute, but off the top of my head, I'm not sure I remember. But on a personal note, I can kind of tell you, you know, it wasn't anything, you know, significant. I had a catalytic converter stolen, and, you know, the police showed up. You know, it was a theft, and this was in Howard County. At the end of it, they gave me a pamphlet that basically said, "These are your rights as a victim," and I think it included information about Vine. I don't have it anymore, and it's been a while, but
And Vine's all jurisdictions, whether you're on MDAC county or not, that's irrelevant. All jurisdictions have access to Vine.
no, I believe the Vine is MDEC jurisdiction. There's a different procedure for notification if in non-MDEC jurisdictions, and that's when it falls on the state's attorney.
I appreciate the information, but to be clear, we're not talking about Vine here. We're just talking about the prosecuting attorney reaching out to the victim, right? Or the victim's representative, right? So I totally, Right, so I totally understand what you're saying with regard to getting other people involved, or not having control of the information, or not wanting other people to know, but this is, I mean, if you want to just put it to just the victim, then obviously if it's, the victim isn't alive, then that's something else. But, I don't know, I guess if there was any way to keep this in, I think it's important. And I would think the most prosecutors would say they try and do this anyway. And I don't know, I think it's important. I know they would say it, and I would hate for this, and I just hate for this to be, they don't want to be mandated to do it.
Maybe you need to take out the, if the victim's representative has not filed, like, how would the prosecutor know that? If they filed a notification request for him?
I would not even put that in there, right?
Yeah, so maybe if you say reasonable effort.
Right.
But then you get back into the issues that Jamie mentioned, which is that you've got an email address, or you call the house, and she's living with her parents, but she doesn't want them to know that there was a sexual assault. She wants that for her, and doesn't want that to go out to the family at large. Or the email address that you got on file isn't just like go to her personally in her iPhone. It's kind of goes to the family computer or something, and now you got state's attorneys emailing stuff out. It could become rather, I mean, if they're mandated to do it, they got to do it, and now they.
Who would be the victim's representative?
It's defined.
Is there a presumption here too, that there's kind of an implicit presumption that there has been contact between the state's attorney and the victim already here, right? Or were you thinking that, no, not necessarily?
It might not be at that point, because this is the arrest. The guy's been arrested and released on bail.
So it's not necessarily. Yeah. All right.
Here's another one. Same person you talked to. So victims are given the option to sign up because the practice of being victim-centered and trauma-informed involves providing choices. Also, information, emails, phone numbers are sometimes shared with victims and their abusers and abusers' families, especially in DV cases. Finally, corporate victims typically don't care, so that's extra. I mean, I'll make the motion to strike it, just to, and if it's seconded, is everyone okay? I'll do it.
Strike the whole thing or just that part?
Just that one part, just, so, page 2, little 2, under section 11-104, Roman numeral 2. It's been seconded, is everyone okay? Okay. Absolutely. I think that's like, I want to fix that, or explore that, so. Okay. Is everyone okay then adopting this? The amendments have been adopted. Is everyone okay voting for this package, and we'll hold it for the rest, for this bill? So 586, the middle one. What this basically is going to do is to make a recommendation to the Baltimore City delegation. Sorry, we're not going to pass this out of the committee, just to say in voice that the Baltimore City delegation will have a review of this. This is the 586. So the chair of the delegation of Baltimore City has said that it would provide us an opportunity to present this package, which is all Baltimore centered, for your bless off. Get the bless off, come back here, we can vote it. Okay, so is everyone okay with making this recommendation to the Baltimore City delegation? Okay, great. For the first package, 763, we were going to convene the state's attorneys and the Department of Public Safety with Senator Sidnor, Senator Carter, and Senator Huff. And we'll come back and make recommendations, work it out. Great. That's it. That's it.
So, we made some tweaks. Are we gonna have the tweaks ready by Friday? The delegation?
God will, the delegation's already, we tweaked it. It's ready to go for your consideration. And we'll have a reprint ready for you guys, yeah. And God bless, you guys meet at 8 o'clock still?
I think so, because we still meet at 9:30, right?
Yeah, but, okay, so Jamie and I will be available to present or with you, Senator Carter.
I'm happy to, well, this is Corey McCrae's bill, he'll present it.
Yeah, but he doesn't know exactly how we've changed it, but,
I'm happy to tell him.
okay. All right. Stay tuned for voting on Friday. No, not right now. Oh, wait, Senator Zucker's bill? Okay,
That's important.
so whose bill, is that Heather's bill? The funding for the,
What's the bill?
she's not, we can do that this week, don't worry. Okay. All right, because we want to make sure we're moving the funding mechanisms in tandem into the hearing. All right, that's it. All right, see you all tomorrow.